Yes, counsel.
Good morning. May it please the court. Jeffrey Baylor for Leslie Cheremond. First off, we contend that the so-called prior bad act evidence was erroneously admitted at trial.
Mr. Baylor, could you, I know there's some from 2007.
Yes.
Just, could you sort of give the time frame, the number of prior bad, I know I should remember this, but I don't.
Yes. There was some from 2007, which was more than a year before this incident.
Related to the restraining order.
Related to the restraining order, which had lapsed at the time of the, at the time of the incident. Then there was some that was sort of an unknown time, sometime at the end of 2007, 2008. And then there was some that were just right before the incident. First off, we challenged the affidavit that was admitted, which was executed by the decedent in support of the restraining order. In her affidavit, she said that the defendant was violent, that she was afraid of him, and that she did not want the defendant to hurt her anymore, and that's why she needed a restraining order.
And there was limiting instructions at the time and also in the closing argument, I mean, in the final instructions?
Yes, there was. It was admitted by the judge, and consistent with these instructions were to show that she would not have consented to sexual intercourse with Mr. Cheremond, and to show Mr. Cheremond's motive. Now, without these exceptions, this clearly would have been hearsay. And we contend that neither exception should have been applied. Now, this court does allow an exception for something like consent to sexual intercourse, because it would be admitted for its truth, but rather whether or not she would have consented. But when it's a hearsay statement involved, this court has said it's only admissible if the defendant opens the door. I know in the Commonwealth's brief, they say that the defendant opened the door in his opening argument by saying that there was consensual sexual intercourse. But at the time that this issue was ruled on by the court, there was nothing on the record about the defense. There was a motion in limine filed by the Commonwealth prior to trial. The Commonwealth said, we need to introduce this evidence so we can sustain our burden of proof to show that there wasn't consent. There was no talk about what the defendant was going to be claiming or anything, and it was allowed. And right on the first day of trial, I think it's the third page of the transcript, before any opening or jury selection, the judge said, I'm going to allow this because it'll show consent and motive.
Right, but I mean, you did have, there was DNA found in her vagina from him, so he was going to have to address that issue, and he did, in fact, in the opening statement, speak of consent. So why did the judge err in understanding that that would certainly be a defense when it turned out to be a defense?
Well, I mean, I can't think through what trial counsel's strategy might have been, but he at least would have had the opportunity to weigh whether or not to use that as a defense. I'll just leave the Commonwealth to their proof or whatever might be involved. But in this case, there was nothing saying that this is going to be a defense. All the judge said, well, it's admissible to show consent, and that's what the prosecutor was asking for, saying that's the reason we need it, because
I mean, given the facts, wouldn't, how can you not, I mean, how could a judge think anything other than, there is no other defense?
Well, excuse me, maybe it just could have been left to the prosecutor. I mean, this is maybe the judge, I can't think of what the trial counsel might have done, but again, he wasn't even given the opportunity here to weigh whether or not it's worth opening the door to this evidence or not, because this is pretty powerful evidence. I mean, even the prosecutor in another issue argued that this was similar to the offense that occurred. At least it should have been left to the trial counsel, the defense counsel, to weigh this, whether or not the door would be opened and therefore allow this evidence in. The judge sort of made a preemptive strike, leaving the defense counsel with no choice but to argue it. In fact, when Mr. Cheremond was before he was put on the stand, trial counsel put on the record that one of the reasons that Mr. Cheremond was going to testify was because the affidavit was admitted in. We also contend that it was not admissible to show Mr. Cheremond's motive. Now, this court's rule is that such evidence would be admissible if the defendant knew about it and was likely to act on it. But the court has made clear that just the fear of a defendant does not make it admissible. Usually that kind of evidence is admissible. For example, like if a wife tells a husband, I'm leaving you, and he ends up killing her, that would be something that he knew about and might act on. But here, just because Mr. Cheremond might have known that she was afraid of him or said that he was violent, isn't the kind of evidence that should be admissible. Therefore, it should have been not admissible as hearsay. And of course, this implicates...
So if you're right, then it would have been admitted for the fact that she said it, not for its truth, and it would therefore come in only as to her consent.
If I'm right on the second, but I'm saying that it shouldn't come in under either to show consent or to show motive. And therefore, no exception to the hearsay rule would apply in the statement like this in an affidavit done in preparation for a legal proceeding.
But you still had the criminal subpoena, which came in ultimately as to the issue of motive because she was scheduled to testify against him with regard to those underlying charges.
And that didn't come in until Mr. Cheremond's testimony. At first it was held out. The judge even said that that pushes it over the edge of being more prejudicial than probative. But once Mr. Cheremond testified, it came in. And again, one of the main reasons that Mr. Cheremond testified, as counsel put on the record, was because of the contents of this affidavit.
But are you suggesting that it's not evidence that the fact that someone is scheduled to testify against a person and that person is later killed is not evidence of motive?
I'm not suggesting that. I'm suggesting that it would never have come in unless the restraining order affidavit was admitted in the first place. Because at first, when the judge was going through the prior bad act evidence, the summons wasn't going to be admitted. And it was only admitted once Mr. Cheremond started testifying. And he would not have testified except he felt like he needed to blunt the contents of the restraining order.
And was there a motion in limine before the opening statement also as to the statements that she made to her boyfriend and to her brother?
Yeah, it was part of the same motion. And again, we contend that a similar analysis should apply. The statements, the primary statements were statements made just before the restraining order was obtained. The decedent's brother testified that she had told him that, among other things, that Mr. Cheremond grabbed her by the throat and threatened to kill her and wanted sex. So
this would be back in 2007?
2007, right before the restraining order. So what happened was she told the brother the story, and the brother said, you should go get a restraining order. So it was all this 2007, more than a year before the incident, and by the time this incident occurred, the restraining order had lapsed. So again, we contend that there's a similar analysis that it shouldn't have been admitted for her consent or for motive, but also that it shouldn't have been, even if it was admissible, it should not have been admitted because it was too remote and overly prejudicial. Again, the restraining order and this statement to her brother occurred more than a year before. The restraining order had lapsed. There was nothing to show like an ongoing conduct which would bring the conduct of the restraining order to the time of the offense. I mean, a restraining order lapsing could just as easily have shown that their relationship was fine, not that there was a continuing conduct. So we contend that in this regard, especially the statements relating to prior to the restraining order and the time in the restraining order should not have been admitted, even if it was hearsay, not hearsay, because it was too remote. And of course, it was extremely prejudicial. As the Commonwealth said in their closing, it was very similar to the acts alleged that occurred at the time. So it should not have been admitted because it was too remote and overly prejudicial.
What was the defense?
The defense said it was that it wasn't him, that it was identification.
So what, you don't disagree, do you, that the interaction at the car, Rock's car, would come in?
I mean, right before this happened. Well, I can't say that was too remote, but I can say that it was, again, overly prejudicial. And that, and again, that it shouldn't have come in.
You don't think it goes to motive?
I'm saying that there has to be, I'm not saying that it was
And it's not remote?
irrelevant, it's not remote. I'm saying that it's overly prejudicial, and that the judge should have said, this is overly prejudicial. I mean, I agree that that's probably the weakest statement, but...
Well, I guess what I'm wondering is this. If given the defense, and given that that's pretty powerful evidence, the Rock interaction there, doesn't the sort of relationship before that then become relevant? I mean, in other words, if you didn't have that happening, and all you had was back in 2007, and then life goes on and this restraining order had lapsed, I see your point.
Yes.
But doesn't this kind of reopen the whole issue of
I'm saying that it was such a long time passed, and there was such a break between, it was more than a year before the incident, and the restraining order had lapsed, that I don't think it shows a continuing conduct. It wasn't like it did it 6 months. In fact,
it shows the nature of the relationship and sort of what can happen between them.
Well, I respectfully disagree with that. I think because of the break, especially because they work side by side every day. After the initial restraining order, it was modified because they worked in stores next to each other, and they saw each other every day, and even the Commonwealth's witnesses testified that they thought there was a friendly relationship between the two. So we contend that there was such a break that I don't think that this brings everything back.
Well, you say there's a break, but I think that the order itself went into evidence, did it not?
Yes, it did.
So the fact that they were, during the course of the last year, subject to a restraining order does say something about the nature of their relationship.
But the restraining order had ended by the time that this incident occurred.
A few days before, and then there was a criminal trial being scheduled, a few weeks scheduled to occur on February 26th, which was 13 days after she disappeared, for which she was to be the key witness.
Right. But this criminal trial, even though it was related to the restraining order, it doesn't necessarily say that everything wasn't fine between the two. Because it was a criminal trial based on this thing that happened quite a while ago, it doesn't mean that in the intervening time that they didn't have a friendly relationship, as the Commonwealth's witnesses said, or they were working side by side without any harm.
Right, but the issue is not whether it's dispositive. The issue is whether it's relevant, and whether or not its relevance exceeds the risk of unfair prejudice.
So are you talking about the affidavit now?
No, put aside the affidavit.
Okay.
I'm referring to the order itself, the restraining order itself.
Right. So all we know is there was a restraining order, and there was no objection to the restraining order coming in.
And I gather that also described that the order had been amended to permit him to work next to her.
Yes, it did. But of course, it didn't contain the powerful statement from the decedent, he was a violent man, I don't want him to hurt me anymore. All they would have known that there was a restraining order. So I'm saying that it was vastly more prejudicial to have the affidavit coming in than the order. If there's no other questions on that issue, I'd like to at least mention that there was a McCarthy motion filed in this case based on the rape charge.
Could I just ask you
Sure.
a factual question? Why was the rape indictment sought and obtained a year after the murder indictment?
I think it was because the DNA testing was delayed, and once they got the DNA testing back, that's when they did it. We contend that the evidence presented to the grand jury was insufficient to show lack of consent. Now, rape requires that intercourse be compelled by force or threat of injury, and that there was no consent. The grand jury wasn't presented with anything that might have happened at the time that intercourse took place. The judge said that the evidence was sufficient, citing three things: that there was a restraining order, that there was evidence that the defendant had argued with the decedent, in that she had a boyfriend. Well, none of these, we contend, was sufficient to show that she did not consent. Again, the restraining order had lapsed. It could have just as easily demonstrated that they had a good relationship at the time rather than a bad relationship. She had a boyfriend, but there was nothing to say that it was exclusive, they were engaged, or anything beyond she had a boyfriend, and that they had argued. But there was nothing, again, to say like it was a serious argument or just that there was an argument.
Well, she was found dead. Is that not relevant to the issue of whether or not it was consensual?
It's not relevant because there's no time connection made between intercourse and death. I mean, this is almost like any dead body and semen is found in, then there had to be a rape. I mean, intercourse could have been at any time, could have been totally unrelated.
Couldn't the jury reasonably infer that it was, based on the evidence, that it was probably right then?
I don't believe they could have. There has to be some evidence about, when it occurred. All the jury is knowing that is that she's dead and they find semen, but there's nothing to say that they were connected at all. I mean, I think it would be way too much of a leap to make to say that just because someone is killed and semen was found in that person, that there must have been a rape. And finally, we contend that the closing argument included facts, not in evidence. First off, that the prosecutor misused the propensity evidence. And as I mentioned before, during her closing, the prosecutor said that, look at the affidavit in support of the restraining order. Isn't that similar to the crime that we now allege? And later on, she said, she gave some description of what the decedent's behavior was and said, did she do that only because she knew that the decedent was a violent man? And there was an objection to this, but the trial judge, rather than giving a specific instruction keying in on this language, just again gave the general instruction as to how the restraining order should have been used. The restraining order affidavit should have been used. And we contend that, again, this was highly prejudicial, as it showed that the jury could have concluded, if he had done exactly this behavior a year ago, then he must have done it now. And this language was clearly inappropriate. There was also a misstatement of the DNA and also the length of the strangulation. I'd just like to mention that length of strangulation because I think that it wasn't objected to, but I think it's really clear. The medical examiner testified that brain death would occur in 4 to 6 minutes. She was specifically asked how long the decedent might have been strangled, and she said she didn't really know, but brain death occurred in 4 to 6 minutes. However, the prosecutor argued that she was strangled for 4 to 6 minutes. Therefore, that was plenty of time for premeditation, which we contend is a total misinterpretation of what the medical examiner was saying. And this is...
But I don't understand that. She's strangled. It takes 4 to 6 minutes for someone to be brain dead from strangling. Therefore, one can infer that she was strangled for more than that.
Well, okay, I guess I missed an important piece. She said that there was a compression of the trachea. So to me, that means someone's neck is squeezed, the trachea is compressed. It doesn't mean that it was held all that time. It just means it was compressed in. And specifically, I have the quotes in my brief, but she said she didn't know how long someone would have been strangled, only that that's brain death. So it could have been 1 second the trachea is compressed, and that time.
That's a question of fact, then, isn't it? It could have been. It could have been for 4 minutes.
Well, I'm saying that
4 to
isn't
6 minutes.
it's not a reasonable inference from what the medical examiner's testimony was. That wasn't what the testimony was. The 4 to 6 minutes was brain death.
Mr. Baylor, we have to leave it
Okay.
there.
Thank you.
Good morning. May it please the Court. Robert Bender, Assistant District Attorney for Middlesex, appearing for the Commonwealth. With me is Elizabeth Keeley, who tried the case for the Commonwealth. Well, let me just, my recollection of the testimony of the medical examiner here is that she wasn't sure how long the compression of the trachea was to cause bleeding in the muscles around the trachea. She was very clear that the strangulation and brain death would come 4 to 6 minutes after oxygen was cut off to the victim. First, a loss of consciousness, and as long as the oxygen was cut off, there would eventually be brain dead in 4 to 6 minutes.
And did she say that death was by asphyxiation as opposed to from loss of blood from the stab wounds?
There were no stab wounds, but it was not not bleeding itself that killed. It was asphyxiation as the specific cause of death.
Was there testimony that suggested that a compressed trachea would necessarily cut off all oxygen to the...
Well, the testimony wasn't merely that the trachea was being compressed. There also was a description of abrasions and bleeding of the teeth against the gums caused by, in her opinion, blunt force being applied to the mouth and nose area. Also manners of cutting off the breathing and cutting off the air supply. So this was the nature of the testimony as to how the dynamic was the death was caused.
So the strangulation itself, well, the asphyxiation could have been caused by other than strangulation. Strangulation may have been a contributor to the asphyxiation, but not the exclusive cause of the asphyxiation. It could have been blood. It could have been a compressed trachea.
All these different things were identified as things that were done to the victim in the course of time that resulted in air supply being cut off for 4 to 6 minutes, causing her death. The compression of the trachea was so severe that it caused bleeding in the muscles along the trachea. That was where the testimony was. She didn't know, the pathologist didn't know how long it would take to cause that bleeding specifically.
Was there testimony that the trachea had been compressed in such a way that it alone would have cut off an oxygen supply?
Without the hand being on
Without
it?
the hand being on it?
No, I don't recall that was said. It was said that putting the hand there and compressing it with such force as to cause bleeding in the muscles would cut off the air supply. But it was also identified that other things were being done.
Is a compression of the trachea the equivalent of a fracture?
No.
So the compression of a trachea is the application of force to the trachea.
Yes.
When the force is removed, the trachea returns to its original position? Is that the science?
You've gone beyond the testimony here, so I'm not really qualified to say what the science is.
All right. This wasn't a consultation. I was just asking.
I understand. I mean, there wasn't a question as to how often have you seen a trachea injured in this way with the bleeding. That questions like that weren't being asked. It was, and here in the context of this appeal, the question was: is it reasonable to say that the defendant was acting in cutting off the air supply for 4 to 6 minutes, resulting in her death, in that period of time being sufficient to premeditate? This is a rather straightforward testimony and was argued straightforward manner to the jury. There wasn't any error there whatsoever. The same can be said about the testimony about the Y chromosome evidence, the frequency test, reference was there. The testimony was not as clear as it might have been, but it was that there were 16,000 profiles to check, and the DNA that was found did not match any of the 16,000, and that meant it had a frequency of no more than 793, I think, was the number for people of the defendant's background. And it was said by the witness that if it had matched any, then it wouldn't have been as high in frequency. It wouldn't have been that not matching anybody was the best number for the Commonwealth that was possible. And this is what the Commonwealth argued, that the testimony was that result, although it was narrow, 793 is not anything like the 20 followed by 12 zeros or the 60 followed by 15 zeros of the DNA from the vagina and from the anal swab and from the chewing gum. But it was fairly and properly represented and didn't mislead anything. As far as what was argued and what my brother calls propensity argument,
why wouldn't it have been appropriate to, if you're going to go back to 2007, to have the evidence of the restraining order what did the affidavit add? Isn't there a real risk that that's going to be taken for its truth?
Well, its truth, the statement on the affidavit is actually the victim's state of mind. She's saying, what is my state of mind at this time? And this is all. She doesn't describe the event at all in her affidavit. She says, my state of mind is this. I am afraid of the defendant. He is violent. I don't want him to be around me.
Well, he's violent. I guess I wonder why.
Well, I think that why it came in is because it was just, it gave the only, in fact, it's the only evidence that comes directly from the lips of the victim.
Well, that doesn't make
I know, but in the sense of completeness, it's there. It is, although in this case, completely cumulative, because unobjected to, when the boyfriend, Rock, testified, without objection, he's saying that he discussed, he had discussions with the victim about her feelings towards the defendant when he found out that after their confrontation 3 days before the murder, what their prior relationship had been like. And he said the victim at that time said to me that she thinks the defendant is violent and he's possessive. This came in without any objection whatsoever, and it, I say, covers the same ground as the affidavit here. So as I rely on the case of Commonwealth versus Burgess, that takes care, really, of the sole error here, which is one of whether this is testimonial statement that's been introduced. It was introduced properly.
How much?
Otherwise,
I'm a little. I'd just like to explore the use of these affidavits a little bit with you. What if the affidavit had, in addition to what was in it, had said something like, "Oh, and by the way, I talked to his prior girlfriend, and he put a knife to her throat and threatened to kill her," and that was in the and I'm afraid he's going to do that to me too. Could that part of an affidavit have gone into evidence?
well, first of all, the affidavit of the Commonwealth will recognize is testimonial. It was made in an application for court relief. It's not, it falls under what the Supreme Court has now classified as a testimonial statement. So testimonial statements are not generally going to be admitted without an opportunity to cross-examine unless they come in under this hearsay purpose, the state of mind of the victim that we're talking about here. And even then, they're not generally going to be allowed. So I wouldn't see that the Commonwealth would be routinely offering up something just because it's in an affidavit attached to a restraining order application. That doesn't mean that it's something that's going to be able to miss it, despite the fact that it's a statement from the victim that's there. But that's not the statement that was in this affidavit. And I say that's why that I think that the use of the affidavit in this case was harmless beyond a reasonable doubt, because of it was also duplicated by what the victim said to Rock, who testified, "This is what the victim told me. He's violent and he's possessive."
Was it not error for the judge to allow it to be used for motive?
The affidavit? Well,
I mean, her general instructions with regard to all the prior statements, regardless of whether they came from the defendant or came from the victim's brother or from her boyfriend, is that it comes in for the state of mind of the victim, including consent, motive, and the relationship between the victim and the defendant. And it seems that it would only come in, unless it came from the defendant himself, it would only come in as to the state of mind of the victim.
well, I think it comes in as to the state of mind. I think, this is also in combination of the fact that in her purse, in her pocketbook that was recovered, with her body, was a copy of this restraining order and a copy of the summons that had been issued to her. I suggest two things. One, this goes to the other primary objection of the year-old restraining order. It had run for a year. It was certainly still in the mind of the victim, we know, because it's in the pocketbook of the victim. I carry this restraining order with me, even though I'm working next door to the defendant as allowed in the order. I have the summons with me to go to court to testify. And again, that shows that her concern or her concern with the defendant continued. It didn't just disappear.
I understand why it comes in as to her state of mind. My question
comes
is,
in also-
was it error to allow it to come in as to his motive, apart from the criminal complaint, which I understand is separate?
Well, I don't know that the jury was required to find that it was his motive. The judge gave the same language as to each of the pieces of evidence that came back. Excuse me. And here I think the key thing is given her state of mind, as was said, she was not someone who was likely to have consented to have a sexual relationship with the defendant, as the defendant said on the stand, as the defendant said in his opening, as the defendant said in his argument on the McCarthy motion, that there was no evidence that there wasn't consent. He said we had such a relationship. One can assume that we did have consented intercourse. And there has to be some explanation for his semen being found on her, consistent with having intercourse with her.
But you still haven't answered the question of whether or not it was error to allow it to come in for purposes of motive, of his motive.
I'm not really sure I can say that it's error.
Why isn't it?
Well, if you're saying it's error, you're saying that the judge shouldn't include something in addition to other valid reasons.
Right.
No, actually, my concern is that her statements may come in not for the truth of the matter asserted, but simply because she was saying them, and the fact that she said them goes to her state of mind, regardless of whether they're true or not. But once you begin to get to the issue of his motive, then her statements are relevant only because they are true, and then they would be both hearsay and testimonial. That's the concern.
Well, I can only take it back to the court's consistent position that a victim's fear isn't considered evidence of motive, and in that, if you're looking at it in that kind of isolation, that these are just statements of fear or expressions of fear, the court has said repeatedly that those are not probative of motivation.
But the judge told the jury that they were.
The judge told them that they can consider this when they decide whether there is a motive. The
right?
judge didn't say this is motive. The judge didn't draw any conclusions for the jury at all. But to say,
No, I understand that. But she said you can consider them on the issue of his motive, correct?
But her instruction wasn't changed depending on which piece of evidence that it was that she's referring to. She's referring to all the different evidence of prior bad acts that were introduced, some of which went to motive. Specifically, all the testimony that Rock provided the jury at length as to what happened on the Sunday before she disappeared, where the defendant came and confronted her and berated her. It appeared to Rock that this was the first time the defendant realized that she had a boyfriend. This then was supported by testimony from Edith DeHady, who was the former hairdresser, who said that on Monday morning, by the time she finally turned on her phone and started talking to the defendant, he'd been calling almost, through the morning. And they talked for hours, how the defendant said that he wanted her back, she had a boyfriend, and what was going on. All of this testimony, which was a substantial portion of what was coming in, goes directly to the motive of the defendant. And I think for me to say the judge erred because she didn't break it up in her instructions to say, this testimony you can consider for motive, this testimony you can consider for this, all of it is correct. Some of it goes more heavily towards one element, and some of it goes to other elements. But that's what her instruction was, and I don't think the court would come back and say, this was an error, it was something that should have been objected to, it shouldn't have been said this way, and therefore there should be a new trial because this is how the judge gave the instruction. That would be new ground to do that, and I think this is not the kind of a case where all these different types of testimony says that there was no basis at all for the judge to refer to motive. In the context of all this evidence, there was plenty of basis to refer to motive. So I can't tie it to, well, in the context of the affidavit, no, it didn't go there, but much more attention was brought to what Rock and DeHady were testifying to than to the affidavit. As far as what we go on here, I spent some time in the brief, I think pages 24 to 28, discussing how for every point that the defendant points to as something that was objected to, there was evidence not objected to that made the same points that came into testimony. I've mentioned, the long discussions from Edith DeHady, the former beautician, as to what the defendant said to her, as to her feelings about his feelings about the victim and the relationship that he wanted, and how about there being a new boyfriend, a new man in her life, and the defendant's desire to have her and to have themselves be living together. This testimony came in without any objection whatsoever and really casts a great deal of light as to his state of mind. Rock testified as to the conversation he had with the victim after the defendant had come in and confronted them outside the salon 3 days before the murder. And at that time he said the defendant came to him personally after the victim left the car and said to him, people get killed for this kind of thing, interfering with relationships.
Am I right in understanding that the defendant testified that, or at least acknowledged in his testimony, that his relationship with the victim had its ups and downs?
Yes.
So that it was the admission of this affidavit consistent with, I'm trying to figure out why the lawyer didn't object. Is it because they were, the affidavit and the 209A were consistent with what his testimony was, that the relationship had its ups and downs?
He did object.
Well, the defendant gave a lengthy explanation as to what the ups and downs were, and that he basically attributed them to his unwillingness to marry the victim, and that she really got very upset with him. The original restraining order had to do with an argument about whether they would get married. Her moving in and out of the house, which is normally supported by his testimony, again turns around arguments about whether they should get married. The argument, he says that in the last period of time, even though they weren't living together anymore, they would go off to motels and have sex. He couldn't really take it to the apartment that he shared with his cousin, but and even on occasion they would have sex in his store. And then he gave testimony saying that on the day before the murder, that's when he had intercourse with her. It was consensual intercourse. It was in the store. And it was to rebut this that he was then made to read the affidavit where the victim said that she's afraid of him and his violence. He doesn't want to have anything to do with him. He was asked again to explain what had happened at the issuance, that the defendant couldn't explain why the victim said to her brother, this is what happened when I went out to get the restraining order. It wasn't on anything to do with, I don't want to marry you, I don't want the wedding date to be set. It has to do with this violent attack upon you. So his testimony was, I wouldn't say based on what he heard in the courtroom, but it was based on his view of how their history had been, which was as different at every point as it could be from what the testimony was the Commonwealth put forward and what the evidence they put forward, and as to the history of this relationship. He didn't say that he didn't point to really any up point at all, except for his allegation that they had consensual sex at various times, and that they were able to continue working next door to each other without any intervention by the authorities during that time. I'd be remiss if I didn't mention one other thing, and that's that the brother testified, and as did a client of the victim testified, that the victim wanted to move away at the time of her death. She said, I want to move to South Florida where we have other family and I will be a beautician down there. I don't want to be near the defendant anymore. Again, that goes, I think, across the board to how this relationship was not good at the time of her death. She didn't want it, and she didn't want to have anything to do with him other than what was necessary to keep her store running. And that's what the evidence was admitted for. It was done properly. I ask you to affirm this judgment as murder in the first degree.
Thank you. We'll take a brief recess.